Miranda vs. Arizona by Nick Cashin, Cody Dell, Shane Willett, and Mike Saba. Background: up until the late 1960s, law enforcement was not required to inform people of their rights at any time. This led to many unjust convictions because many people had no knowledge of their Fifth or Sixth Amendment rights, such as the right to remain silent, the right to an attorney, and that things you say can be used against you in court. The case. On March 13th, 1963, Ernesto Miranda was arrested based on evidence linking him to the kidnapping and rape of an 18-year-old girl. Without knowing his rights to counsel or being advised to remain silent, he was interrogated for 2 hours, which led to his signing of a full confession to the crime. At his trial, his written confession was used against him as evidence. His lawyer, Elvin Moore, stated that Miranda did not know of his rights and that his confession was not voluntary and should be excluded. Moore was overruled and Miranda was sentenced 20 to 30 years in prison. The appeal and retrial. Moore appealed the case to the Arizona Supreme Court and the original case was thrown out. The Supreme Court, in a 5-4 decision written by Chief Justice Earl Warren, ruled that the prosecution could not introduce Miranda's confession as evidence in a criminal trial because the police had failed to first inform Miranda of his right to an attorney and against self-incrimination. The Miranda conviction was overturned. The results of Miranda v. Arizona. After the ruling, the court made it clear the proper procedure after an arrest and during an interrogation. After an arrest, the person in custody must be told of their right to remain silent, that anything he says could be used against them in court. He has the right to an attorney, and if he cannot afford one, one will be appointed to him. During an interrogation, if at any time the suspect wishes to remain silent, the interrogation must stop. If the suspect requests an attorney, the interrogation must stop until an attorney is present. This is the official Miranda card. Number 1, you have the right to remain silent. Number 2, anything you say can and will be used against you in a court of law. Number 3, you have the right to talk to a lawyer and have him present with you while you are being questioned. Number 4, if you cannot afford to hire a lawyer, one will be appointed to represent you at county expense before any questioning. Number 5, if you give up your right to remain silent and later wish to stop answering questions, no further questions will be asked. The waiver. Do you understand each of these rights I have explained to you? And having these rights in mind, do you wish to talk to me now? And then they sign it, and also the officer advising the rights needs to sign it, and then they time and date. Some thought-provoking facts. Miranda was released from prison after serving only 8 years. Miranda also told his wife that he was willing to marry the victim if she would drop the charges. After the trial, he sold autographed Miranda rights cards for $1.50 each. And Miranda was stabbed and killed at a bar. The culprit was ironically read his Miranda rights. We're excited.